Greetings everyone, welcome to my YouTube channel. I am Advocate Pule Matsilo. Today I will be teaching the law on interim maintenance in South Africa. The key word there is interim, because we know that there are cases where people can apply on behalf of their children or even spouses on behalf of themselves to court to obtain maintenance. And in those instances, we just talk of maintenance because there is an obligation on the parent or the parents or the spouse or the ex-spouse for one reason or another to maintain the applicants, be it children or spouses, as I have just indicated. Now, in the case of interim, the key word there is interim. In the case of interim maintenance, is called interim because this is an instance where it's a temporary measure. This happens in cases where there is a divorce pending, and before the finalization of this divorce, a party, in terms of the rules of the court, can apply to court for an interim measure, which is an interim relief. When you make that application to the High Court, it's in terms of Rule 43. That is why in most instances it is called a Rule 43 application. And when you apply to the magistrate court, the same application, it's in terms of Rule 58. But in most instances, people will be talking of Rule 43, Rule 43. For the mere reason that in most instances, divorce happens in the High Court. And it will be very rare for a person to take that, to remove that application from the High Court to the magistrate court, though it is allowed. The reason for this interim maintenance is to enable the party to meet their needs whilst divorce is pending, as I've explained. Because you will realize that in most instances, or in some instances, divorce proceedings can go on, can drag on for years. Now, this Rule 43 or this Rule 58 in the magistrate court, it's used as an intervention. It's used as a lifeline for those that are vulnerable. So for those that need to be maintained whilst the divorce is pending. However, let me hasten to mention that once we call it interim, it does not mean that at a later stage it will be finalized or it will be granted as a final order. It may be, but for now, the concentration will be on maintenance as an interim order, as a lifeline for those that are vulnerable. The affectors or the relief sought may not necessarily involve maintenance only. The relief sought may include things like, number one, child or spousal, if the spouse also has a need. Number two, the applicant in this application can also ask for contribution to the costs. Because you must remember that divorce proceedings, or even this very Rule 43 application can be very expensive. Legal processes can be very expensive. So the party, whilst applying in terms of this Rule 43, Rule 53, Rule 58 rather, can also ask for a contribution by the respondent to the costs. Thirdly, the issue that will also be discussed here is the interim primary residence. Now that we are waiting for divorce to be finalized, it's not yet finalized. Where will the child stay? Where will the children stay? What will be the primary residence of this child? Because the divorce is not yet finalized and we are still waiting for a court to issue an order to that effect. The other thing that will be sought in this interim application is contact with children, what we used to call visitation rights. How will it go? If the children's mother's residence is the primary residence, when will the father visit? When will they visit? How are they going to share contact of the children? So these are some of the things that will be included in the relief sought in terms of this Rule 43 application. So it's very, very important to know that it does not mean that because the divorce is not yet finalized, it means that people must just stay there and be helpless. The other parent being stuck alone with children without the assistance of the other one. This is the reason for this Rule 43 application. I hope you found this very helpful, but what I need to mention is that the law as regards maintenance is evolving every day. Recently, there was a decision taken by the court where a man did not pay maintenance for 30 years. There are issues of prescription, but the court ordered that it does not matter even if it was after 30 years. He was ordered to pay 3 million for the outstanding maintenance that he did not pay all along. So this shows that the court, as the custodian of children, is very proactive with regards to maintenance as regards the vulnerable in our society. So I hope you found this very helpful. Thank you very much. If you haven't subscribed, please click that button, subscribe. Please comment. Please also share this video so that other people can have information. Thank you very much.